Sure, I'm Steve Shapiro. I'm the National Legal Director of the ACLU. I was been very lucky in my career. I went to law school thinking that I might at some point, if the stars aligned, wind up doing constitutional litigation at the ACLU. And it turned out to be the first job I had following a clerkship, and I've stayed here ever since. No, I very much grew up in the 60s and lived through that rights revolution at a moment in time, maybe an historical anomaly as it turns out, but a moment in time when the courts really were agents for progressive social change and for protecting and promoting more rights for more people. And so I went to law school thinking that that was the kind of work that I wanted to do. My father was a New York City civil servant, but a frustrated lawyer, I always thought. My sister went to law school before me, and so I followed in the career path, and I took a lot of constitutional litigation, constitutional law. From some very good teachers when I was at Harvard, came out, got a clerkship, and then really, as I said, in many ways lucked into a position at the ACLU. I clerked for a judge on the Second Circuit whose name was J. Edward Lumbard. He had been Chief Judge of the Second Circuit for many years. He was a close friend of Justice Harlan. And by the time I went to clerk for him, he had recently gone senior. He was probably in his early 70s. He had a very different set of politics than I did. He was I would say, a Dewey Republican, an Edwardian gentleman. He had been the U.S. Attorney in the Southern District of New York, and is given credit, and I think properly given credit, for really creating the office that we now know as the Southern District of U.S. Attorney's Office. He brought in the best and the brightest, and a tremendous number of alumni from that office, then went on to serve on the federal bench. And it was, I think, even though he was only U.S. Attorney for a couple of years, the formative experience in his life. He was very much thought like a prosecutor, but had tremendous faith in the system, and therefore a tremendous commitment to seeing that the system operated fairly, and was more upset because his expectations were higher than others might be when he thought the system failed, either the public or the defendants. He didn't delve deeply into doctrine. He was a pragmatist, but he taught me a lot about how the judicial process works. He taught me a lot about writing, and the last thing he said to me when I went to say goodbye at the end of my clerkship year was, he said, "Steve, if you've learned nothing else from me, I hope you've learned the value of an afternoon nap." So I've taken that lesson with me also for life. That's fair to say. In most cases, even in a court like the Second Circuit, of course, do not go to the United States Supreme Court. It just like the vast majority of cases that the ACLU handles don't go to the Supreme Court, even though we have a fair number that do. And what I thought was very good about Judge Lumbard is he obviously tried to follow the law. He understood he was bound by what the Supreme Court said, but he pretty much did what he thought was right. And I remember saying to him one day, how do you feel when a decision of yours is reversed by the United States Supreme Court? And he looked at me and said, "I think they're wrong." Well, I was doing what all federal appellate clerks do, but this was back in 1975 and 1976. It was a quieter time. Circuit judges had only 2 clerks then. They didn't have 4. And we read briefs, we prepared bench memos, and we drafted opinions for him. I did, although this is a story that I love to tell to aspiring law students. I was sitting in chambers sometime in the spring of 1976 trying to figure out what I wanted to do with my life, or I knew what I wanted to do with my life, just trying to figure out how I would get there. And I saw an announcement for what at the time was a relatively new fellowship at the ACLU called the Karpatkin Fellowship. It was the second year of the Karpatkin Fellowship. And it was to come work at the ACLU national office for 1 year, and I applied for it and never heard anything. I certainly didn't get the job, but as I recall it, I never received a rejection letter either. It just, my application was met by stunned silence. And then about a month later, I got a call from a woman named Marcia Lowery, who worked at the New York affiliate of the ACLU, the New York Civil Liberties Union. And she called me to say that she was looking to hire a young lawyer to work on what was then called the Children's Rights Project, which really did institutional reform litigation involving the New York City foster care system. And she said, I got a list of candidates who had been finalists for the Karpatkin Fellowship, and your name was on the list. Would you like to come in and interview for this job? And my first reaction was, I was a finalist. Nobody ever told me. But I did go in and interview for the job, and I wound up getting that job. And it was fortunate in many ways because the ACLU was much smaller in those days. And had I actually received the fellowship, I almost certainly would have left after 1 year. There wouldn't have been any other opportunities, and my career would have gone off in some other path. Because I didn't get the 1 year fellowship, I wound up getting a full-time job. And I came and did that job with Marcia for, I don't know, a year and a half or 2 years, got a lot of very helpful and useful litigation experience. But then there were a variety of people at the New York office of the ACLU who were moving on for one reason or another. And so there were some openings to do what we think of as general civil liberties work instead of specializing in one particular area. And I was always interested and have remained interested throughout my ACLU career in the opportunity to work on the range of issues that the ACLU works on. So I moved over from being a specialized lawyer working on these institutional foster care cases to an ACLU generalist. So I did a lot of First Amendment work. I did some Fourth Amendment work. I did some equal protection work. I did what ACLU lawyers and ACLU offices do, and I stayed there for almost 8 or 9 years. And then there was an opportunity to move to the national office of the ACLU, first as deputy legal director in 1987, and then as the legal director in 1993. So I have been the ACLU's national legal director since 1993, and part of what I have done at the ACLU since really I came to the national office in 1987 was to supervise all of the ACLU's work in the United States Supreme Court. So for the past 25 years, I have been intimately involved in every case that the ACLU and every brief that the ACLU has filed in the United States Supreme Court, and that's a lot because we're a pretty frequent participant. Well, the way the ACLU is organized, and part of the strength of the ACLU as an institution, is we have a national headquarters, primarily located in New York, but with a lobbying office in Washington. And then we have state offices in every state of the country. I directly supervise the legal work of the national office. I do not, on a day-to-day basis, directly supervise the work of the state affiliates. So their decisions about whether to take cases or not are made at the state affiliate level, and not only I usually do not have any input into that decision. I often don't know about it because it's a big organization and there are a lot of litigations going on at any given time. But the place that the litigation program gets centralized is when a case is heading to the United States Supreme Court. So whether it started in the national office of the ACLU or started in a state affiliate of the ACLU, if an ACLU lawyer thinks a case is a candidate for us to seek Supreme Court review, or if an ACLU lawyer receives a petition for certiorari from the other side because we have one below, the case at that point comes to me. And I will make the final decision about whether we are going to petition, and if the petition has been filed against us, then I will work with the lawyers to shape the op cert that we are going to file, and if a case reaches the merit stage, then I will work and have final edit on any brief that is submitted to the Supreme Court, and will work to ensure that the lawyer who is going to be arguing the case is properly prepared to argue the case. That's true for the direct cases we bring to the Supreme Court. We also have a pretty active amicus practice to the Supreme Court, and the amicus practice much more tends to, not exclusively, but much more tends to start with me. I follow the Supreme Court docket, identify the cases where we have an interest and I think we might have something to say. I then try to map out what it is we're going to say and figure out who then is going to draft the amicus brief.